the Supreme Court has agreed to hear the case of Dobbs versus Jackson Women's Health Organization, addressing the constitutionality of a Mississippi state law prohibiting abortions after the 15th week of pregnancy.
We have a human being 15 weeks old, and people believe that you ought to be able to destroy that life. We don't. So I'm very encouraged about where we're at. I hope at some point Mississippi is free of abortion.
In the case, Mississippi is defending its law against a challenge by the state's only licensed abortion facility, Jackson Women's Health Organization. Many are calling this the most significant abortion-related case before the Supreme Court in nearly 3 decades. That's because Mississippi is asking the Supreme Court to overrule Roe v. Wade, the 1973 Supreme Court decision that required abortion to be legal in all 50 states, as well as Planned Parenthood v. Casey, the 1992 decision that continued Roe v. Wade's abortion guarantee. On March 19, 2018, the Mississippi State Legislature passed House Bill 1510, aka the Gestational Age Act, prohibiting abortions after the 15th week of pregnancy. This is a human fetus at 15 weeks. They are roughly 4 inches long, they have all of their limbs and organs, and can yawn, scratch their head, and suck their thumb. The primary procedure used in abortions after 15 weeks is a D&E, or dilation and evacuation.
Second trimester D&E abortions performed between roughly 14 and 24 weeks of gestation. After suctioning the amniotic fluid out from around the baby, you introduce an instrument called a Sofer clamp. It's about 13 inches long. It's made of stainless steel. The business end of this clamp is about 2.5 inches long and 1/2 inch wide. There are rows of sharp teeth. This is a grasping instrument. When it gets a hold of something, it does not let go. A D&E procedure is a blind abortion, so picture yourself introducing this and grabbing anything you can blindly and pull, and I do mean hard, and out pops a leg about that big, which you put down on the table next to you. Reach in again, pull out an arm about the same length, which you put down on the table next to you, and use this instrument again and again to tear out the spine, the intestines, the heart and lungs. Head on the baby that size is about the size of a large plum. Can't see it, but you've a pretty good idea you've got it if you've got your instrument around something and your fingers are spread about as far as they go. You know you did it right if you crush down on the instrument and white material runs out of the cervix. That was the baby's brains. Then you could pull out skull pieces. And you have a day like I had a lot of times, sometimes a little face comes back and stares back at you. Congratulations, you just successfully performed a second trimester D&E abortion.
On the same day that the Gestational Age Act was passed, it was challenged by Jackson Women's Health Organization. A Mississippi federal district judge struck down the act, declaring the bill unconstitutional. The decision was then appealed to the Fifth Circuit for review, but that court affirmed the lower court's ruling. The case was then further appealed to the U.S. Supreme Court, which agreed to hear the case.
There's 2 main ways that Dobbs is different. The first is sort of broad and philosophical, which is that we've now had almost 50 years of case law after Roe, and this is the time where A, the state of Mississippi is directly asking for Roe to be overruled, and B, we now have a lot of evidence of why Roe should be overruled. Now, things have happened that are similar to that in the past. The second, more practical answer is we have 2 new justices on the Supreme Court, Justice Brett Kavanaugh and Justice Amy Coney Barrett, who have not had the chance to rule on an abortion case.
The Dobbs case calls into question existing Supreme Court decisions governing at what point in fetal development the state is allowed to restrict abortion. Right now, Supreme Court cases say that there is a constitutional right to abortion until a preborn child is viable. According to the court, a child is not viable until he or she has developed enough to have a realistic probability of surviving outside the womb. This is generally considered to be around 24 weeks, though in close cases, the person performing the abortion determines the child's viability.
Viability, when they say it legally, means can this child survive outside of her mother? That is an interesting question, but it has nothing to do with whether a preborn child is human, right? That's the question we should be considering when we talk about whether we ban abortion or when we ban abortion.
The court has officially only agreed to answer a single question: whether all pre-viability prohibitions on elective abortions are unconstitutional. Mississippi's brief argues that nothing in constitutional text, structure, history, or tradition supports a right to abortion. It contends that the only reason the acceptability of its law may seem difficult to determine is because Roe v. Wade and Planned Parenthood v. Casey hold that the Constitution protects a right to abortion. As a result, the brief argues, the real question of the case is whether the court should overrule those decisions. Their answer? It should. A decision from the Supreme Court will most likely be delivered by next June, after the case has been argued.